Benjamin Bryant, and I am partner at Bryant and McKinnon Lawyers here in Coffs Harbour. We're going to talk specifically about mediation. Mediation is a process that touches most family law matters, whether they're in court or out of court. So we think it's a great idea to focus specifically on the mediation process. On my far right, we have business partner and accredited family law specialist, Heather McKinnon. And we're also joined, you can see, by a gentleman in the middle of us, Mr. Peter Marr. Welcome, Peter.
Thanks, Ben.
Excellent. Peter is a mediator extraordinaire, and I understand he's been an accredited specialist since 1993, and since 2009 has been doing court-appointed mediations here in Coffs Harbour and around New South Wales, and I think you may have done over 300 mediations or so now.
Well, that actually, I've actually done pretty close to 1,000 mediations now. Since
Indeed.
Yes, I was shocked. I actually had to count them up recently, and I'm very close to completing 1,000 mediations.
Well done. So, if there was someone to ask a question about mediation, it'll be you. All right, Peter. Let's start with the basics. Okay, what exactly is a mediation, and how does it differ from other alternative dispute resolution processes?
Look, that's a good question. A lot of people think that mediation is something magical. It's an opportunity, really. It's an opportunity for people who have problems to take control of those problems and the situations that they find themselves in, and find a solution. It's bringing people together. It's trying to give them power over their own lives and their own situation, and it's giving them the opportunity to speak either directly with one another or through their representatives with one another. It's not very different to what we do every day within our families, whether those families are intact or they're separated. It's about it's not very different from when you're selling a car. It's giving people the opportunity to say, I can come to an agreement with somebody else about resolving an issue.
And being involved with the court-appointed mediations, you would be mostly talking about property mediations.
Yes.
And there's other types of mediations. I might ask you, Heather, different types of mediations or processes whereby what Peter was talking about, that facilitate communication between the parties.
So when Peter and I became lawyers, we only knew about litigation. That is, if people couldn't sort out a problem, you went to court. So over the last 40 years, we've developed all different techniques to help people solve problems other than court. So mediation in the family law arena, most people will access it at the beginning when they've got a dispute in their relationship through the family relationship centres, which are dotted all around the countryside and are funded by the Attorney General. And those, the mediators who are employed there, their main job at the front line is to help couples sort out arrangements for children. So for many people that are separating, that's the first chance they get to understand what is mediation. It's a very a process that's been well developed over time, but it's a little bit different than the work that Peter does, in that the work that the relationship centres do is really mapped out in a model that we know works to get parents starting to talk about kids rather than fight about kids.
And that's why I asked the question, because I know a lot of people use the word mediation to cover a lot of situations, but family dispute resolution or mediation at a family relationship centre looks very different to a mediation with Peter in relation to property issues. And so, Peter, not anyone can just be a mediator. So tell us, how do you qualify to be a mediator? What do you need to do?
Well, firstly, you have to have recognised qualifications. I can talk about my qualifications. I was encouraged to go to Bond University, and I did a course through Bond in mediation. And once I had completed that course, I was then, and I must say, as a lawyer, that course was extremely demanding. It was over an extended period of time. And actually, one of my tutors said to me the biggest drawback that I had was that I was a lawyer, because we, as lawyers, we tend to concentrate on facts. So we want to know what the facts are of something, and of course often that's not, the facts are not actually all that important in the mediation process. What's important is how people are going to resolve the dispute that they have about the facts. And so I got qualifications through Bond. However, once you've got those qualifications and you're acknowledged as a mediator, then you have to register as a nationally accredited mediator, which I've done, and have been, had that recognition for many years. And then what you have to do is you have to gain a further qualification, which is a family dispute resolution practitioner. Now that qualification is not easy to get. I did it through online, actually, through the University of South Australia, their social science department, and those qualifications then are recognised by the Federal Attorney General, and you are then qualified to conduct mediations in the family law dispute area.
And we know that mediations can happen for parties that are not litigating, they're not at court, can happen when the matter is at court. And for some unlucky couples, they also get to mediate again after. When do you consider mediation is appropriate, or when someone should consider mediation?
Look, Ben, that's a very good question. It's a very hot topic at the moment. The Parliament is considering that at the moment, and I think, although it's not a secret, but in the near future, couples are going to have to go to mediation. I think prior to initiating property proceedings. The question is that a good thing? If I can just go back to your initial question, is when is the most appropriate time to mediate, I suppose. It's a very personal thing, and some lawyers prepare their clients very early on to go to mediation, and those lawyers are skilled. And the client is, if the client is prepared at that particular time early on, then that's appropriate for them. Now, in terms of compulsory mediation, I'm one of the people who has a few question marks about going early before initiating proceedings. I was wrong in terms of parenting, so I most probably will be wrong in this as well. Parenting mediations have worked very well, and a lot of people resolve their disputes about children at early mediation. Property, however, I think is, and I hope I'm wrong, property is a little bit different. It's the last thread of a marriage often, or of a relationship. So going early when you don't, to mediation early, when you don't understand what the alternative to that is often not very helpful. Like, for example, you do see people in mediations where they say, oh, well, what I'll do is I'll go to court. Well, yes, that's exactly what you're going to do, and it's going to cost you a lot of money to go there. But they don't quite often understand, and especially if their lawyers haven't prepared them, then they don't understand what that "I'll go to court" means. So I think the ideal time for a mediation is after people have initiated proceedings in the court, they've actually been to court, they've actually seen what the alternative is to resolving their own thing at an agreement, and then they come along to mediation. Now that's just my personal opinion. It's not shared by the majority of people, but it's my personal opinion.
And so a lot of what you were talking about, Peter, depends on preparation. So I think, Heather, perhaps you could discuss with the viewers what are the types of things that we do prepare for a mediation, or to manage people's expectations as to what's going to happen at a mediation.
So we know that the two biggest areas of dispute in any property carve-up are what are the assets and what are they valued at. The problem with going to mediation unprepared is that you will never get an answer to those first two steps. So before going to mediation, we get clients to understand why it is really important that the couple have a very accurate idea of what their net worth is. So we're heading into an economic downturn. Client after client I will see, and they will indicate that their net worth is, $1 million. And when you start focusing down on their level of debt, you realise that their optimism has led them to believe that their assets are probably worth a lot less than what they think. So if you have couples who don't have a realistic idea as to what their assets and liabilities are, you can get a lot of problems with trying to get solutions because they think they're a lot wealthier than they are. Or conversely, couples will come up with a figure, for example, on the value of a business that they've just drawn out of the air. And unless they face the reality of how the court approaches the valuation of businesses, and that their understanding before the mediation of the real value of the business, it's not likely that Peter's going to be able to get very far. So the role of the solicitor in preparing the client is to make sure that they absolutely have a good understanding of the balance sheet. What are the assets that we both control? What are they worth? And what is our debt level? Sounds simple, but the work in getting that done, I know, for example, in our practice at the moment, we've got valuations being done on two very big businesses that have taken over a year of incredible work from a big team of accountants and valuers. Now, if you put those cases before a mediator like Peter too early, the chances are you would never get anywhere at a solution.
That's right, because it's all very well to come to an agreement as to the percentage. A lot of people think there's this mythical, 50-50. But the question is 50-50 of what? And if you don't have that grounding, then it makes it very difficult.
And the financial planning aspects of settlement are critical. So you have a category list, you've got real estate, you've got shares, you've got superannuation, you've got business assets. What we have to do with our client is get them to focus on what will my life look like in the future. Do I want to operate the business, or am I happy for it to go to the other party? Do I want to live in the house that we bought together, or do I think it's better that it gets sold? It's no use leaving those decisions to the mediation. They've got to be thinking about the solutions way ahead of entering the room.
Absolutely.
Could I endorse that, Ben? Because I mean that's really something that's absolutely critical. I have a colleague that I work closely with, Philip Theobald, who's been a mediator for many years, and he thinks that's a critical issue. We often talk about that because if people come along and they haven't got a clear understanding of what their property pool is, then there's very little we can do. As a mediator, I'm not a valuer. I'm just not a valuer, so I can sit there and say, well, how are you going to solve it? And often people will solve it by saying, well, we don't know what it is, but we can live with this value. That's all right. That's fine. But it is critical if there is a real fight. For example, you can have somebody who can say, this business is worth $500,000, whereas the other side will say, this business is me, and it's worth $50,000, which is just the tools that I've got in the shed or whatever, the equipment. That's an impossible situation because the expectations are that somebody is going to get a share of 500,000 or 50,000. Well, that's a bridge. It's a gap that you can't bridge. So.
And Heather, I think we touched upon this, the balance sheet and valuations. When I wasn't here, I was holidaying in Cairns, but you had James Davis from HQB here with you, and I remember you went through with him, financial planning and the importance of understanding the value of the balance sheet. So if you have any questions about that, about different advices or financial advice and when to get financial advice, tune into our webpage because there's a lot of interesting resources on there taken from your discussions with James, and also on our Facebook page, of course. It'll be available. So, Peter, unfortunately, there's a reality that of family violence. Okay? Yes. Is it appropriate for there to be mediation in circumstances of violence?
Look, I was recently at a conference in Melbourne where there were a number of retired judges who were practicing as mediators. Very impressive people. The question was asked, is it appropriate to, exactly what you said, is it appropriate to have a mediation when there has been family violence? I think we all thought it depended, in this conference, we all thought that it depended on the type of violence and the type of mediation. So sometimes you could have an incident of very overt physical violence, which may have been a one-off situation and was not something that was present the whole time through the relationship. You may think that physical violence would impede the mediation process, whereas in comparison you may have a situation where there has been a gnawing, overwhelming power imbalance within the relationship. And you have to be very careful about both of those situations. Number one, you need to protect the people who are coming along to the mediation. They need to be safe. So I was a very strong supporter, and in this conference that I went to, so I was very surprised. They asked who put the people together, and there were 12 people in the room at this conference, 12 of us. I was the only one who put people together. And that shocked me.
And that's the problem with judges becoming mediators, because their whole work life has been in a situation where they haven't had to have people communicating.
That's right.
There is a real risk, I know, before Parliament is this suggestion that we're going to have judicial mediation. The character types required for those two positions, mediator and judicial officer, in my view, are very different.
They're very different.
And certainly the question in relation to violence is one that the lawyer who's acting for the victim has to really make sure that victim is well supported by social scientists, so has a psychologist or mental health social worker on board, that you know what their limits are, and that they are confident enough that with your support they won't decompensate or feel under enormous stress if they're put in a situation where they're facing a perpetrator. The other advantage of getting a client to a stage where they can face the perpetrator in a mediation is, if the mediation doesn't resolve the matter, the next time they see the person will be in court, which is another 100 times more stressful.
Yeah.
My experience is that particularly women victims of violence who are well supported from separation until mediation, which is usually about a year, if they've had really good therapeutic input, it can actually be very powerful for them to attend a mediation, look the perpetrator in the eye in a protected environment, and start to negotiate their financial future. Now, it is a radical suggestion, but I've seen it over 4 decades. The power in taking back control of your own life and the way that you're going to be able to achieve a financial settlement that'll allow you to move forward. So, you know, it's complex, and that's why you need very senior people. But certainly when Peter and I are in a mediation where we know that the parties have consented to mediate even though there has been a history, we've got to be very careful through the day that we are monitoring whether someone's coping with
and
the
that's
stress.
what I was going to ask. In the more serious end of the violence spectrum, if we could say that, Peter, what are the types of measures that you can put in place to ensure people that they will be safe at all times throughout the mediation process?
I mean, if you... I've only had a few mediations where I've actually called a halt. I've said, no, this is inappropriate to mediate this any further or to even start. I had one, I remember clearly, where I didn't even start it. I said, no, I've made the assessment that it's not appropriate. So I agree with Heather, you have to be very careful. If people say they don't want to be in the one room, you can point out the advantages of being in the one room, as Heather has done so well. But if people say, no, I don't want to be, then that desire and wish has to be respected. Okay, well, we'll do it a different way. The way we'll do it is we'll have it by shuttle, and that is that each party remains in the room, in a separate room, and there's the lawyers can talk to one another and or talk to me, and so I can be the conduit through which people talk. I would like to go back to the point that Heather had made, Ben, and that is that it's very interesting when you see people that do become quite empowered by the mediation process. So sometimes you can read the papers in a matter and you think this is inappropriate for the parties to be together. So you might say that, and they sometimes they will say, oh no, look, I'd like to do this, I'd like us to go together. But yeah, the opportunity to face this is a demon that I have and I'd like to face it, that's fine. I have seen people change before my very eyes, and I think most probably Heather has, other lawyers certainly would understand what I'm talking about. And you actually see them change, and you see them all of a sudden not be put down. You see them take control of the situation, take control of their own life. Yes, I will do that, but I won't do this. And it's very moving to be a part of that.
Absolutely.
So there's I think there is not one set rule. You have to play it, and sometimes people won't go into the room at the beginning, but after a while they say, oh, look, I'd like to go and make a comment about that. The disadvantage of people not being in the room is that the lawyers then can be in control, and that's not.
And careful,
yeah, that's right. I've got to be careful, but the mediation can be their mediation then, you see, and that's not really what it's about. I was in a mediation just recently where there were very senior lawyers in it, not in this area, but where I had to say to one lawyer, look, I don't think you're listening to your client. You know, you're not listening to what your client is actually saying here, because they were both going down totally different paths. The client was saying, look, I can cope with settling this matter on these particular terms, and the lawyer was saying, no, you can't possibly settle the matter at all on those particular terms. And I'm thinking, I don't understand what's being said here, you know. So I called it out and said, maybe you've got to take a break and have a talk and listen here, you know, about what goes on. But violence is a really, it comes in many forms. It comes, often you think you understand what family violence is about, and you don't. Often you think you've got a handle on what this is about, and you don't. And it's not exclusively male against female, though that is the majority. You know, but so I'm really conscious of it, and I'm not somebody who gets frightened by argy-bargy or aggressive behaviour, but I think you do have to have a very good antenna for what is serious and what can get out of control, and you've got to be able to make a decision and make that decision quickly for the purposes of safety.
And we've touched on it already, Peter, but what can people expect? What can a party expect in the mediation process?
Well, that's interesting, because I think a lot of people come into the mediation process and don't quite know what to expect. I can only talk about my process, but I think I run, well, certainly Philip Theobald and I run a very similar process. The first thing we do, if people do consent to come together, we tell people about who we are, because we're barging into their lives. We tell them what process we hope to follow, and that is, number one, we have a look at what the balance sheet is. We look at what parties agree on and what they disagree on. We don't encourage a fight about that. Well, okay, you disagree about that, about the value of the house. Is there a valuation? Yes, there's a valuation. Well, if there's a valuation, how are you going to get over that hump? I mean, if it's a valuation, I'm not a valuer, you're not a valuer, there's the valuation. Well, you often get people who will say, well, I just don't agree with it. Okay, well, we'll put it down over here, that, and we can talk about that later. So that we can get at the bottom of that, then we get a total, as Heather was saying, so we know what that's about. Now, once we've got a total, I like to ask people, well, now, what's your best shot? What's your best case? What are you actually asking? Now, surprisingly,
a lot of them never thought about it.
It's not about that, and they'll say, "Oh," and even some lawyers will say to you, "Oh, I need to get some instructions." I mean, we're at the mediation. You know, I mean, we're at the starting gate, and all of a sudden you go, "I've got to tighten the girth." Well, I mean, you should have tightened it earlier. So now I must say the lawyers working in the Coffs Harbour area are very good. You know, they generally, everybody has got that under control. You know, they know what they want and then they speak to it. Now, why is it that you think your client should get 60% of the pool? So then they'll speak to that. Now, the advantage of that is that the other side hear it. Now, there's been these reams of paper that have gone back and forth that the clients really, and I'm not criticising the lawyers, but the clients don't understand that. There's a lot of legal talk about sections of the Family Law Act and all of it. But to hear it come from the mouth of the party and say, either from the party or the party's lawyer, generally from the party, in front of the other party, they'll say, oh, is that what they want? Yes, that's what they want. well, I'm going home. You see, you often get that response. Well, don't go home yet. That's just what they want, right? So it may not be what they get, but it's what they want. So at least everybody knows what they want. Now, once we get to that stage, generally what I do is I say, now, I think, unless anybody's got something else to say, we'll have a break. Now, sometimes that's been quite exhausting getting to that stage, especially if it's a mediation that hasn't got a time limit on it. I mean, I did one mediation where it took us 2 full days, 16 hours to get to that point.
Because in that point you're discussing the balance sheet.
The balance sheet, that's exactly right, yeah. And then it took us half a day to settle it. You know, so but generally once you get to that point of knowing what the balance sheet is and what the other side want, you can go away. Now, then I can move between the parties and I can speak to them. Do you understand what the other side want? Do you understand this? Do you, you know, and I can help people come to grips with that and to try and put the emotion aside, which is very easy to say and very difficult to do, but at least marry the emotion with the mind and say, well, this is what people want. Do you really think that's what they want, you see? If you say that to them, do you really think that's what they want? Often they'll say, maybe not. So then you start the thought process going into a different direction. Well, if it's not what they want, so it's like a dance. This is a dance. It's an orchestrated dance, and my role is to try and get the parties to dance with one another, to try and get them to understand what their optimum position is. Try and understand then what, if they don't settle it themselves, what is likely to happen if they go to court. Have a look at what the cost of that is, and will the cost, I mean, my father was a bookmaker, Ben, so I like to look at it and say, well, I do the odds on it. If you're going to spend $50,000 going to court, what are you going to benefit? You might win your case, but you come out as a net loser. So you might spend 50 and pick up 20. Now that's bad balancing of the books. So how do you know, what alternative, where are you likely to end up if you do take it to court? Look, it's a very long-winded answer, but one of the things that I always think is that nobody actually, when they come to a mediation, nobody actually is telling the whole truth and nothing but the truth. Every one of us holds back a card, and sometimes you can look at and you can see it in people's eyes, the card. You can see them. Do you really want the lawyer from the other side to be probing around in this area? Do you really want that? You know, now their answer often is, oh God, no. Well, that's what's in front of you, unless you're prepared to dance. So,
well said. And is the process, Peter, different if the mediation or the parties came to you ordered by the court, or if it was you were privately engaged, whether before litigation or during litigation?
Look, yes, the process is different because you can't offer the time. I mean, court-ordered mediations are limited to 3 hours. Now that sounds a long time, but it goes like that. So you haven't got the luxury of letting people vent for too long. People come along, they're in distress, they want you to understand that they're in distress. They want me to understand that they're in distress, that they've been battling, that their relationship has hurt them, or the breakup of their relationship has hurt them. It can be a hurt by surprise. Their partner may have behaved very badly. they may have caught them out behaving badly, or it's just been a gradual deterioration of a relationship over a long period of time. But they're distressed and they want you to know that. And I can't very well say to them, oh look, that's not important, you know, I mean, you can... See, the reality is that a lot of the things that the client thinks is very important, the lawyers think isn't important at all.
And I think the biggest example of that is what you were saying, where the judges that you were talking to in Melbourne don't do mediations where people are together. I suspect that's because if you're brave enough to put people together, you see grief. So we see grown men in their 50s bald, and you know, we see emotion at its rawest. When people are trusting of the process and trusting of their lawyers and the mediator, that often will happen, and you will always get settlement. If you don't engage in that process, the chances of settlement aren't as great. But we're privileged every day of our lives in this field to actually see people reduced to the absolute depths of grief and then let go. And what it is about mediation is the skill of the mediator is getting the people to the stage where they let go what they've been invested in for years.
That's right.
It's a real breakthrough.
I mean, the difference in between a court-ordered mediation and a private mediation is that you do have more time, and you have more time to explore possibilities. Sometimes I feel that I cheat on people a bit in the court-ordered one because you know, or I get
to keep it moving.
You got to keep it moving, and you've got to say, look, it's, you know, you've got half an hour, you know, and so it's in the private mediation area, you've got more time to be empathetic and to actually try and work out. I mean, look, there's one example that comes to my mind. It was quite a complicated mediation where one party arrived with virtually a truckload of documents into the room, and we went. It was a private mediation, but we went for a long time. And when it really got down to it, when people got down, what was it? And I was thinking to myself, what is it that is the blockage? There was clearly a blockage. What is it? Anyway, one party said, you are accusing me of stealing money. That's what you are doing. And it was out of the blue because nobody had actually said that. All that the lawyer on the other side had been doing was doing their job, asking for documents. Disclosure. You see, disclosure. It's the bane of my life. But anyway, disclosure. And they'd been producing all these documents, and the other side had been producing all these documents. There's a myriad of paperwork. But when this party said, you are accusing me of stealing money, the other side, the client on the other side, said, you know, I have never accused you of stealing, and you know that I think you are an honest, honourable person, right? Yeah. He then the client who said that then broke down and said, if you think I'm saying that, I'm sorry. That's saying I'm sorry. Settle the matter.
Wow.
Just settle it. Just like that. Just all
and
over.
The pile of documents were...
Pile of documents. Totally irrelevant then.
And that's why mediation is magical sometimes.
And sometimes it is. Yeah, sometimes.
Peter, the final question for you this afternoon is that what is necessary for a mediation, in your experience, to be successful?
Ben, if you know the answer to that, please tell it. Oh, look, I've spent a lot of time in country motel rooms and hotels, I suppose, thinking about that and taking notes about that. Look, I think there's a couple of things. They're certainly not exhaustive, but the first thing is that the clients are prepared generally for what's going to happen. That's number one. That they, I mean, sometimes clients will arrive and they'll say, I didn't know he was going to be here, or they were going to be here. Oh, well, yes, they are. So I think you'd go out and you think, oh, this is going to be a difficult one. So if they're prepared, if the client is prepared for what generally is going to happen, that's huge help. Even more than that is, I think, is if the clients are represented by lawyers, the lawyers are prepared. Now, if the lawyer arrives and says, I've got to get some instructions about what my client wants, there's type of a bit of a problem, that is not generally able to be overcome at mediation. So the lawyers need to be prepared. Thirdly, people have to, in that preparation, have to be prepared by their lawyers to move from their optimum position. If you come along and you just say, I want 75% of the asset pool, and you're not prepared to move from that, then the process doesn't work. I mean, I've used this example many times. Some time ago, I tried to buy some cattle from a man who was totally uneducated, and used to wear bare feet in the cattle yard and a big hat, and he stood about 4'8" tall. And he bred wonderful Angus cattle, and I had my eye on half a dozen, and I said to him, Joe, I'd like to buy those cattle, and here's the money, I'd give you this for them. And he stopped, and there was a dead silence for 3 minutes, and he said, you want one for nothing. And and I did, I suppose, but we entered then into a bargaining. I said, oh, what do you mean? No, I want this amount, this. And so there was a back and forth until we reached a deal. We reached a deal, and that's what mediation is about. It's about reaching a deal that both parties can live with. They don't have to be right, but they can live with it. This is my deal, and I can live with it. So that's important, to be able to move from your position. And the other one, which I think is really, really important, if parties come into a mediation with expectations that are unreal, then they, if, for example, if their lawyer has told them that they're going to get X,
and they anchor on it,
and they anchor and set their anchor into that, then it's very difficult to settle it, because they have to move from there to settle it. So good legal advice is essential to get people within the boundaries of possibilities of what a court will do. Now, experienced lawyers know what the range is. They just know that. Inexperienced lawyers battle with that, but good family lawyers know it, and they can deal within that, within that range, and their clients know what the range is. That doesn't mean that the client's happy about it. They might say, well, I don't,
But what about...
that's right, what about, and I did, and she didn't, and all she did, the most, vigorous thing she did was get a latte, I had said, one bloke said, or go to Neutral Bay and get a hair done. Or he never did anything, but if they know what the range is, and you can say to them, well, what do you think's going to happen if you go to court? Where do you think the judge is going to lob with this? Do you really think the judge is going to give you 80%? Do you really think that? And if they've been prepared, they'll say no. No. So, well, why are you going to outlay all this money to go there and get a result within the range that you... So I think preparation, if I had to have one word, it would be preparation. Preparation. It makes it work, and and it can happen in all sorts of ways. Really, but preparation. Yeah.
Perfect. All right. Thank you so much, Peter. For Heather and I, this show really is our intention. Really is to empower people. Yeah, to help them make informed and better decisions in relation to their family law matter. And you being here today and taking the time to discuss what you've discussed and has been really, really important to our intention and help us realise that. So thank you.
Thanks, Ben.
And thank you again, Heather, for joining us. All of this will be available, of course, on our Facebook page and on our website at bryantmckinnon.com.au at that stage. So if you have any questions, even about mediations that perhaps that we haven't addressed in this show, or in relation to family law generally, please don't hesitate to send us a message on Facebook, or you can send us an email at familymatters@bryantmckinnon.com.au. All right, till next time.